We go back to what we call Jurisprudence 1. We are going to what we call the relationship, the difference between law and morality. So we have to know, as we talked about what is law, we said law does not have a conclusive definition. The different scholars have attempted, depending on which school of thought they belong, to define what law is. The naturalists believe that law is one that conforms to nature, morality, justice, fairness. The positivists, law is a command from a political sovereign backed up by sanctions for breach. The realists, law is what the judges make. The historical or the historians believe law is a creature of historical or past events. The sociological school, law is that looks at the challenges affecting the society and tries to come up with a solution. Basically, you have to know there is no conclusive definition of what law is. Then you got what is morality. Morality comes from the word morals. Morals, basically, these are acceptable behaviors in a particular area. Morals, morality, empisa, eneisa. That is what we call morality. So, while you're looking at the relationship between law and morality, you have to look at it in 3 stages. The first one is the early stage. The early stage, you have to note that there was no distinction. There was no total distinction between law and morality. That can be seen with Austin. Austin, in his command theory, he said that no. Law is law, and morality has nothing to do with morality. Morality has nothing to do with the law. So, in the early stages, such as Austin's theory of the command theory, said that law is law, and morality has nothing to do with morality. There is no distinction between law and morality. You also see Kelsen's pure theory. Kelsen's pure theory. I told you Kelsen came up with what we call the grand norm, or the aspect of hierarchy of norms. In his separability thesis, he had 3 theses: the command, the social, and the separability thesis. So in the separability thesis of Austin, of Kelsen, he said that law is law, and it is totally distinct from others don't have nothing to do with morality. Basically, we see they are trying to show that morality in the early stage and the law, there was no difference. So we see in the modern stage, there is an attempt to define or to divide morality from the law, and it is seen from the Greeks, the Sutra and the Vedas, the laws that were applicable in Greek, the Sutra and Vedas. The Romans, all those who are trying now to show the aspect of morality being different. The aspects of the inner morality, the heart and fuller debate. We get all of those are now trying to distinguish morality from the law. The inner debate, or the heart and the fuller debate, among others. John Stuart Mill's theories of law, they are trying to distinguish morality from the law. Now, after we've seen that, we have to totally distinguish between law and morality. I'll begin law, morality, law, morality. So, the first distinction with law. Law is certain. What is law? Law is certain, meaning that law is clear. It is clearly known, as prescribed in Section 29 of the Penal Code Act, ABCD. It is certain. That's why when we see our Article 28 sub Article 12, any law that is not written and its punishment prescribed is not law. So law must be certain. All law is certain, but morality is not certain. There is no book that writes principles of morality. No. It depends, or it comes from the people. So law is certain, morality is not certain. Law is coercive, morality is not coercive. Coercive, law always provides a sanction. Also, when you go to the command theory of Austin, law must always provide that penalty in case you breach it. But for morality, it's not certain. Law is written, while morality is not written. Law is enforced by state. It is the state that enforces law through its state agencies, such as the judiciary, while morality is not enforced. Obedience of the law is compulsory, but the obedience of morality is not compulsory. If for me drinking alcohol in public is good for me, and for it is not good, you cannot force me. So obedience of the law is compulsory, and obedience of the law, morality is not compulsory. Are we together? We have to know very many differences or similarities between law and morality. Then let's go to what we call the similarities between law and morality. So the similarities are law is basis. morality as the basis of the law. So similarly, morality is the basis of the law. So that is the first similarity. The law is aimed, or it is based on morality. The law intends to bring morality, so it is the basis of the law. Morality is the basis of the law. From the morals, they get the law. Morality is a test of the law. So the first one was the basis of the law. 2, morality is the test of the law. Test of the law. The test of the law meaning that in sometimes morality tests the law. When you go to the aspect, you go to the penal code, there is a full chapter on law offenses against morality, such as incest, among others. So sometimes morality tests the law. For a law to be valid, does it conform to morality? So it acts as a test. Akakungunta. Morality are the ends of the law. Ends of the law. The aim of the law is morality. The aim of the law is fairness. People having good nature, end of the law. Yensonga lwaki bateekawo morality, etteeka lijja ku enforcinga mpisa, kukwasisa mpisa. All of that is what we call morality. So there are various scholarly views on regards to morality. You look at the Hart and Fuller debate. All those are in the aspect of morality. Thank you very much.